The royal household is not a party to these proceedings, nor does it comment on matters before the courts. The statement came directly from Buckingham Palace. It was short, carefully written, and unmistakably final. Issued just hours after renewed public accusations by Prince Harry, the message drew a sharp line. A line the monarchy had avoided drawing so clearly until now. Harry's claims, once focused on the press, had expanded. This time they reached inward, pointing toward his own brother and sister-in-law. The palace did not respond with emotion. There was no denial, no rebuttal, no defense. What it delivered instead was something far more deliberate: separation. As Prince Harry appeared in a London courtroom pursuing legal action against associated newspapers, his public language shifted. His case was no longer framed solely as a fight against tabloids. In court filings and public remarks, he suggested something deeper, something more personal. He implied that Prince William and Catherine had failed him, not just emotionally, but institutionally. He portrayed years of conflict with the media as a battle he fought alone. A battle where, in his telling, the people closest to him did not stand beside him when it mattered most. The palace response was not personal, it was procedural. Senior officials emphasized a long-standing constitutional rule: the monarchy does not interfere in active legal proceedings. Not for family, not for allies, not under pressure. This rule exists for one reason only: to protect the independence of the courts and to ensure that royal status never appears to influence justice. In other words, the silence was not rejection, it was doctrine. Behind closed doors, however, concern was growing. Sources close to the royal household describe unease about how Harry's accusations blurred a critical line. The line between personal pain and institutional responsibility. The royal family has endured criticism before. For generations, silence has been their default response, but this situation was different. Harry's claims did not just criticize decisions, they implied moral failure. They suggested that senior working royals were complicit, indifferent, or negligent, that escalation required clarity. The palace did not answer accusation with accusation. Instead, it returned to values. Alongside the official statement, senior figures reaffirmed the rules that govern royal conduct. No royal intervenes in private lawsuits. No royal office shields individuals from consequences tied to their own choices. Public duty does not exist to resolve private disputes. Those principles were reinforced most clearly by Princess Anne. Come before, though she did not mention Harry by name, her words during a separate public engagement were widely understood as a response to the unfolding situation. The monarchy, she said, is sustained by duty, restraint, and respect for the law, not by grievance, not by emotion. Personal feelings do not override public responsibility. Inside royal circles, her words carried real weight. Princess Anne has long served as the internal guardian of discipline. When she speaks, the institution listens. Her message reflected a distinction the palace now insists on restoring: the difference between being a member of the royal family and being a working representative of the crown. Benenja's Prince Harry, having stepped away from royal duties, no longer operates inside that system. His legal strategies are his own. His media engagements are his own. His public accusations are his own. This distinction sits at the heart of the palace's position. Officials stress that the legal case does not involve the monarchy. It does not involve royal finances. It does not involve royal authority. The crown is not a plaintiff. It is not a defendant. Any attempt to frame the trial as a moral showdown between the royal family and the press, they say, is simply inaccurate. More pointedly, palace sources rejected the idea that Prince William and Catherine had any duty to intervene. Standing as the future king and queen consort, their responsibilities are defined by continuity, stability, and service to the nation, not by involvement in private legal battles rooted in unresolved personal grievances. Men's privately aides expressed frustration at what they described as emotionally charged allegations surfacing only after institutional assistance had been declined. The palace does not deny that Harry sought advice in earlier years. What it disputes is the expectation that advice could evolve into endorsement of litigation, strategies, public attacks on journalists, or claims lacking clear evidence. Plans for the royal household, the issue has shifted. This is no longer just about Harry's dispute with the media. It is about precedent. And if personal conflicts are allowed to pull the monarchy into legal warfare, the institution itself becomes vulnerable. And so the line was drawn. The palace will not comment on testimony. It will not respond to accusations raised in court. And it will not allow the monarchy to be cast as either villain or accomplice in a scandal it does not own. Damdi, as one senior official put it with measured restraint, compassion does not require complicity. And family does not override the crown. And inside the High Court of Justice, the tone could not have been more different. As proceedings continued, the gap between Prince Harry's public narrative and the legal demands of the courtroom grew wider. And what had once been framed as a moral fight against intrusive journalism was now under strict examination. Evidence, timelines, documents. Cross-examination, emotion carried little weight here. At the center of the case stood Prince Harry himself. His testimony aimed to establish a pattern of unlawful information gathering by British newspapers. But as defense counsel reviewed emails, dates, and social connections, a more complicated picture emerged. Median legal analysts observing the trial noted that many of Harry's claims relied heavily on inference rather than direct proof. MBNDA allegations of conspiracy were challenged by records showing lawful journalistic access, social familiarity, and in some cases voluntary engagement with members of the press. The defense did not need to prove absolute innocence. They only needed to present reasonable alternative explanations. And in that they succeeded. One issue proved especially significant personal agency. The defense argued that during his years as a working royal, Harry actively participated in a media system that involved both cooperation and conflict. Banned to invitations to private events, shared social circles, informal contact with journalists, these were not framed as wrongdoing. They were presented as realities of royal life. The argument was not that Harry welcomed intrusion. It was that the boundary between access and abuse was not always clearly defined or consistently enforced by him at the time. And as this phase of the trial unfolded, Harry appeared increasingly alone. No senior royals attended, no statements followed. The absence was noticeable but expected. Buckingham Palace had already made its position clear. No royal would comment on or attend legal proceedings involving a private individual, regardless of family ties. This neutrality, rooted in constitutional convention, reinforced the palace's separation from the case. Behind that separation lay something more precise. All sources emphasize that Prince William and Catherine had no involvement in Harry's legal strategy, evidence, or public claims. Any suggestion otherwise, they said, was factually untrue. Then came another development. Key members of Harry's legal team resigned. While plan changes are not unheard of in complex cases, the timing raised questions. Former legal professionals suggested that departures at this stage often signal disagreement over direction or confidence in the evidence, not personal abandonment, professional judgment. This only strengthened the palace's view that the matter had moved far beyond royal involvement. In private discussions, aides reiterated a principle long championed by Princess Anne. The institution cannot be drawn into disputes where personal grievance is presented as institutional failure. Support has limits. Ethical limits, constitutional limits. Observers in the courtroom described Harry as visibly strained. The pressure of cross-examination, the exposure, the weakening momentum, but from the palace's perspective, none of this altered policy. Human difficulty does not create institutional obligation. By the end of this stage of the trial, one conclusion was unavoidable. The case was no longer just about media conduct from years ago. It had become a test of judgment, of narrative, of where responsibility ends and accusation begins. For the monarchy, that line remains firm. The courts will decide the legal merits, the crown will remain apart. As Harry's courtroom narrative intensified, senior figures within the monarchy acted again, not to respond, but to define. At the center stood Princess Anne. For decades, she has guarded what officials call the doctrine of restraint, the belief that emotion must never compromise institutional integrity. Her position was clear: duty comes before sentiment. And family does not override constitutional responsibility. Sources say Anne sees the situation as a misunderstanding repeated too often. The belief that the royal family exists to absorb personal grievance, it does not. The institution exists to serve the state. When someone steps outside that framework, the protections of alignment end. And compassion, she has argued, does not include validating accusations unsupported by evidence.